Good morning, everybody. Excited to talk a little bit about SBD force today. Yeah, Mitchell asked me a way back to talk about SBD force. I said, it's straightforward. Why do you want to talk about it? But as Sean pointed out, we had lots of discussions on the group, and also then some of our clients had questions, and then also some one or two that had audit findings on this. So we thought it's an important enough discussion to talk about SBD force today. Just to point out that the SBD force and the SBD force and the MBD force used to be very similar. SBD, obviously, that's for the that's for the PFMA institutions. MBD for municipalities and municipal entities. They talk about the MBDs, the municipal bid documents. So the MBD force and the SBD force. The focus today is really going to be on the SBD force, so the PFMA institutions. There are similarities, but they're not exactly the same anymore. Okay. So as I'll take you briefly just through some of the background to that. When does the SBD4 apply? What, for example, if there are bidders or directors, etc., that are employees of the state or employed by the state, and then some factors around competition commission and collusion. So, as I said, the SBD4 was changed in 2022 when Instruction 3 came out. Instruction 3 of 2022. So if you can recall, you can cast your mind back to about 3 years ago. Treasury issued that Instruction 3. There were a lot of things in it that were covered. Bid committees, some of the other things were deviations, or as it's now called, procurement by other means, etc. So there were lots of things covered, but one of the things then was the modification of the SBD4, and this applies basically to all transactions or procurement transactions, excluding petty cash. Okay, so this must be completed. This document must be completed by all bidders. And it doesn't matter if it's a quotation or whether it is a competitive bid, this particular SBD4 must be completed. And then also, if you can see there, 7.4 say the accounting officer or the accounting authority or the delegate, typically the officials, must, as part of the evaluation process, obviously assess that particular SBD4. And take appropriate actions, and we will discuss some of those actions here. So interestingly enough, it's now called the let me just go back here. It's now called the bidder's disclosure. It used to be called the declaration of interest, and it's now called the bidder's disclosure. The bidder's disclosure also have within it, it's got what previously used to be the SBD8 and the SBD9. Those SBD8 and SBD9s are no longer there anymore, and that's been incorporated into the SBD4, and that's why it's not only a declaration of interest, they just renamed it bidder's disclosure. Okay, and so one of the first questions then that the bidder needs to answer is whether the bidder or its directors or trustees or shareholders or members or any person who have controlling interest in the enterprise are employed by the state. And so that's a yes or no. So they've defined the controlling interest there at the bottom, if you can look at it. So there's a subscript at the bottom, a note in terms of what is a controlling interest. And so if any of those particular individuals then was employed by the state, then obviously you'll have to, the bidder have to declare yes and include the names of those particular individuals in the bottom part. So that's kind of the first part of this thing. And that's very important because that then, I'm going to take us now to the next slide, which then talks about what it is that officials should do if somebody declared their yes. Okay. So firstly, if somebody declared yes here, or bidder declared yes and they have the names there, then the officials in the particular procuring institution, as it says here, if the accounting officer or the delegate established that a person within the bidding entity is an employee of state, that delegate, I'm just going to, not the delegate, must then request the relevant accounting officer or the accounting authority of that particular institution, that other institution, to advise whether the person is, firstly, is prohibited from conducting business with the state in terms of section, I think in section 8 of the Public Administration Act, or whether the person has permission to perform other remunerative work outside of the employment. So the key thing here is that if somebody declares yes, procuring institution must contact that other institution. Okay, the onus on procuring is to contact that other institution and ask them either or if that person is prohibited from doing business with the state, or alternatively has permission to perform other remunerative work outside of that particular other institutions. So that's key. So you as an SCM official then must speak to the SCM officials, must then contact that other organ of state. Okay. Now that's the first part of this thing. Okay, and that relates back to whether they declared yes. But let's say they did not declare yes. Maybe they said they no. Doesn't yet exonerate you totally. Because the other thing that you should be doing then is most probably to go and look at the CSD report of that bidder. And in the CSD report of the bidder, it would typically then say whether any of the shareholders or directors, etc., whether they're employed by the state. So there is an indicator so even if they then declared no, you still have to go and check that. And obviously, if there are people that's flagged up or bidders that's flagged up as employees, or sorry, directors or shareholders are employees of state, then you still have to continue. You have to go and do this particular action as you see on this particular slide. So that's the first thing. Okay. It doesn't mean, important thing again, I'm just going to go back again. It doesn't mean if you've said yes, you are employer of state that you cannot do work. It doesn't automatically mean that you're automatically disqualified. It just flags to say that you then have to go and verify as an official whether you are prohibited in the first place, or secondly, whether you then have permission to do work outside of that other organ of state. Okay, so it doesn't mean you're automatically disqualified, and that's why you're obviously right to the relevant institution to ask them those particular points. So I think that's a very important point: is did you write to them? Did you contact? Did you request that from them? Okay. Interesting enough, it doesn't say here automatically that it means that you must request it in writing, right? But I suppose we typically would send them an email or something, do it in writing. That we do have, from a probity perspective, that we do have the evidence of that. Okay. Now, 758 talks about subsection 1, then talks about the PAMA, the Public Administration Act, and talks specifically about section 8. So I'm not going to go too much on that. I just, for interest, I've put that there for you so you could see it. So section 8 of PAMA then says that an employee may not, and so they define an employee, and it then goes further to say an employee may not conduct business with state or be a director of public or private company conducting business with state. But I wouldn't worry too much about this. I put it here, but as I said, you ask the institution and they must then basically say to you whether the person is prohibited from doing business or whether that person has permission to do business outside of that organ of state. Okay, so that's I think the key thing. The second point that we want to come to then is where you then also have to declare yes or no whether the bidder or any of its directors, trustees, shareholders, members, and partners, or any person having a controlling interest, and we've defined controlling interest before in the footnote. If any of those individuals in the particular enterprise, in the bidding enterprise, have any interest in other related enterprises, whether that other enterprise are bidding for the contract or not. Okay, and so the related enterprise, although it's not defined in this particular instruction, we've interpreted that to mean enterprises that's doing kind of conducting similar businesses. So if you're in construction, any other companies in construction field, or if you're in security, any companies in a security field. So if you're basically a director of 2 security companies, then obviously you would say yes here as a bidder. Okay, or if you're a trustee in 2 stationary companies, you will say yes here. Okay, so as I said, related enterprise weren't defined exactly, but that is our interpretation of it. And important to note, so the bidder must declare yes, irrespective of whether the other enterprise is also going to bid. Because they can always come back and say, but we didn't know that the other enterprise is going to bid or something like that. So you must still declare. It doesn't mean that you cannot do the work. Again, it doesn't mean that you automatically disqualified, right? It just means that you must declare, or the bidder must declare if a director is kind of a director or in two companies, similar related companies. If we then continue with this, and we go to the declaration bit of the SBD4, and we didn't extract everything out of the SBD4, but I just tried to pull out the key important points. So again, bidder would then put their name there, and I'll ask a couple of questions then and that you have to declare, or basically statements and make that you have to declare. Okay, so you then obviously you then have to declare in 3.3 that you've kind of came to this particular proposal quotation that you do independently. You didn't work with any other party, unless of course it was a consortium that you worked in. If you're going to submit as a consortium or joint venture, then that would obviously be an exception. But obviously, if it wasn't a consortium joint venture, that you did work on this bid independently. And that is obviously to kind of prevent then collusion and possible collusion. That is why you then declare that you've done this independently. They haven't had any consultation, 3.4, they have not consultations, communications, agreements, arrangement with any other competitor regarding the quality, quantity, specification, price, including methods, factors or formulas used to calculate prices, market allocation, the intention, decision to submit or not submit the bid. Okay, so you haven't discussed this with any other competitor. Is essentially what you're basically declaring here as a bidder. Okay, and it then goes on. Now, why this is important? Why this is important is because if you look at section 75C of instruction 3, okay, it says there, if there's any suspicion of a transgression of the Competition Act, so basically if there's any suspicion, for example, of possible collusion, okay, then the SCM official, I'm saying the SCM official, but whoever is responsible in the procuring institution must report this to the Competition Commission. Okay, and so this is very important that, so this declaration is that important from a bid perspective is that you basically declaring that there was no collusion. This particular clause then says that if there was a suspicion, it's not even proven, if there was a suspicion, if the SM official for the procuring institution suspects that there was any collusion, you have a duty, it's a must, it's not a may, it's a must that you must report it to the Competition Commission. Very important. Okay. Now, for example, again, and we have to interpret these things because again, the bidder might have signed saying we declare all of these things. But for example, how would you suspect something like that? If, for example, the quotations or the format of the quotations between two bidders are very similar, or if they use the same, potentially, if they use the same telephone number, contact details, those would then all be potential. It doesn't mean that there is a transgression of the Competition Act, but there is then a suspicion of potential that there is then a transgression of the Competition Act. Any of those type of things is then what you need to look at for, and then report those particular factors to the Competition Commission. It also goes down on then further to say, as part of that declaration 3, in 3.5, it then talks about the bidder was not involved in the drafting of the specification or terms of reference for this bid. Because remember that if you as a bidder was involved with the drafting of a particular specification, that could be construed as basically unfair against other bidders. So you had some insight into this thing beforehand. Okay, and they also have to declare that. Okay, no, not declare, but that you are aware that if there are suspicions, as I mentioned earlier, of possible collusion, then that would be referred to the Competition Commission, and there might be indication, if found guilty, there would be possible, imposition or other administrative penalties applied to you as a bidder. So those are basically in a nutshell, some of the things that we have to watch out for and that we have to report on. In conclusion, as I said, I just brought up again the actual declaration there, and saying that the onus is on the bidder to declare accurately. Okay, and so the onus on the bidder, but it doesn't mean that there are not other things that procuring institution can do to check whether the bidder declared accurately or honestly. I think from that is basically from me is basically what I wanted to quickly cover.
Fantastic, Henry. Thank you. That's very, very interesting. So a couple of points in the chat. So Nele, you said that when you checked with National Treasury, they said they don't intend to put this out because they use the MBD forms as the benchmark. That sounds odd. I think the MBD forms came out after the SBD forms, so an interesting response from them. But the question is, do you think it would be of benefit to local government organizations to use this one SBD form that essentially asks two questions? Henry, is that right? There's just two questions it asks, and then there's the declaration. So it's not certainly reduces a lot of the admin workload for suppliers. It doesn't necessarily reduce the admin workload for the procurement practitioners, but interesting. Let's jump through. We've got some questions. Khomotso, good morning. Welcome. You should be able to unmute.
Good morning.
Good morning. Welcome.
Sean.
Yes, good morning. Welcome.
Thank you so much, and good morning, colleagues. Good morning, Henry, and thanks for the presentation. Sean, you recall that I raised these issues on the SBD, around the SBD in the
Telegram group.
Telegram group, and precisely because I've seen that in practice, and I do conduct training on behalf of the NSG, SCM training on behalf of NSG, and when I engage with my learners on this, I get to hear the same story. You recall that on the CSD there is a portion where it talks about the companies that these directors are involved in. So it will just give the CSD numbers and nothing more, right? So you'd find that on the CSD, perhaps there's three CSD numbers there that some directors in this company are also involved in this other company, right? And in practice, what the officials would do, and maybe the colleagues on the line would also talk about their practices. What institutions will do is that they will, on the basis of those numbers that are reflected there, see if there is something that is declared on the SBD4, and if the declarations are saying no, and there is a CSD number on the CSD, they would say then they
Disqualify.
ask to disclose and disqualify. And my argument is on the basis of, Henry, what you touched on around related companies, right? First, and also maybe if you could just go to that 2.3, there's also another element that I wanted to also highlight around controlling interest. That if institutions are merely going to look at the fact that directors also are involved in another organization and just uses that as a point to disqualify, they, on the basis of what they see, they cannot already determine if this person has got a controlling interest, one, and if or one of the directors, if the other companies are related, because I could be in a company that runs a McDonald's and this company I'm bidding for a security tender, so yes, it's two companies, but on the basis of this statement around related, I said no. And then I get disqualified on the basis that another company appears on the CSD. I'm not sure if you're following the part that I'm talking about regarding the CSD, and that's, I think, the biggest point of contention, because it looks like it's happening across the board where practitioners, just on the basis of those that particular information on the CSD, then disqualifies bidders. Thanks. Maybe we'll just hear from
Henry? Yeah, great point there. So in those institutions, Komotso, that you're dealing with, it's the practice that if they do not declare, but they are found to have interest in other companies, they then disqualify them on the basis that they did not disclose. And all they see is that there is ownership in other companies on CSD.
Yes, because looking at that, it just shows ownership. I'll give you another example, Sean. I did indicate that I am a facilitator for the NSG, right?
Sure.
NSG is appointed as independent contractors, so I had to register on CSD in my personal capacity, right?
Yes.
So if you look at my CSD for a company, I would also have another CSD, but then that CSD is for me as a natural person.
Correct.
But then somebody sees that and then already assumes that I did not declare my interest in another company, if you get what I'm saying.
Yes. And the other company might be doing loans or something like that. It might not be anything related to training. Let's listen to Jacqueline, and then we can ask Henry to come in. Hi, Jacqueline.
Hi, Sean and Henry. How are you?
Very good. Welcome.
Okay, I just wanted to find out the SBD form. There's a part where, as the bidder, it gives you an opportunity to declare if you have an offer or offers. It gives you an option for offers, and you submit two offers in which you do declare that I'm just going to make this is a security tender. You one entity they submit their offer and they declare that they also involved with another company that is also tendering from the same tender, and they are now into a joint venture, or they have a partnership. So you have two directors that is 100% control in one company that they submitted their tender, and then they also have a 50% control on a different a company that has tendered, and both companies have declared. what do you do in situation like that? Do you disqualify? And usually with this tenders, you'll find that maybe they need to appoint 5, 10, maybe it's a panel,
Sure.
and both the companies, they part of the highest ranked bidders on conclusion of the evaluations. And the question is that, is it collusion? Because they are 50% shareholder, they're tendering for the same tender. And obviously they did communicate when it comes to the pricing, they did engage because they're partners. The person, this one person is partners in both companies. So what do you do in situations like that? There was one of the departments
question,
that
Jacqueline.
I've done audits on, and they are sitting with the situation because the SBD form, it seems to allow bidders to tender for more than to tender with more than one company, because as long as you declare, and the other company also declares that you are a shareholder and you're also tendering as now as a controlling shareholder in another company. So how do you handle this? Is this collusion?
Good. Henry will respond, Jacqueline. I think you made your point. Thank you for that. Henry, do you want to get to those two questions? So the first one.
So maybe quickly, let me quickly just get to Jacqueline's point.
Okay.
And then we can go back to Mocho's points earlier. So on Jacqueline's point, Jacqueline, so yeah, I'm just giving you my opinion. But my answers was probably driven by the contents of the Competition Act. And the Competition Act talks about obviously defined collusion, and it talks about parallel relationships, etc.
Horizontal.
So horizontal, sorry, yes, horizontal relationships. Now, so if I strictly go according to what the competition defined as collusive practices, that the example you cited would be a collusive practice. I would still report them. In any case, you still have to then report them to the Competition Commission. So from that particular perspective,
so Henry, let's just be sure. There's no doubt, right? The Act says if a director is a common director between two entities that submit a bid for the same tender, it's collusion. That's what the Competition Act says. That's an act. Yeah. It's at the highest, it's the primary level of law. There's no doubt about that.
But
Jacqueline.
With horizontal tendering, also with the Act,
yes,
it's very silent on how you treat it. Remember now, they have declared this is not a situation.
The Act is very clear. It's collusive behavior, which needs to be reported, and they will go through the process of dealing with it as a competition commission.
Yes, I understand, Sean. But what I want to figure out is that, remember now you have the SBD form.
Yes.
Which allows you to declare.
Yes.
And both entities, they have declared.
Yes.
So I think this is all this comes into this declaration because both entities have declared that they are involved.
Jacqueline.
It is up to the entity to test if there was collusion. They might say, yes, I'm a shareholder, but they do their own pricing.
Yes, agreed. But the Act is not unclear, right?
What is the Act saying?
The Act says if there are two directors, if there's a common director in two companies that submit a bid, it is collusion. It doesn't say whether they spoke about pricing, didn't talk about pricing. It says that's the state. If you've got a common director in two entities, it's collusion.
So what I'm trying to understand now, why does the SBD forms allow such declarations to take place? Because it's very confusing.
Because it's not always the case.
Where I have been, It's the fifth case that they're sitting with. That's why I'm raising that.
I hear you. I hear you. But it's not always the case that both entities submit a bid.
But in this specific department, they had 5 cases that they're sitting with where they don't know what to do. And this is the situation.
So Henry, do you want to respond? What should they do? Henry, what should they do?
The organ of state should basically then disqualify and still report. That's my interpretation, Sean.
Do they disqualify or do they report?
They must report.
So if you go,
them.
yeah.
Okay, so I mean, you must report them to the competition commission. That's kind of clear, right?
Do you want to show that? Do you want to show that? Must be reported to the competition commission.
And I mean,
through you, Sean. I think that the tricky part about this whole thing is that the tender documents and their conditions, there isn't a clause that prevent bidders to submit multiple bids.
So, Jacqueline, we've got to understand the hierarchy of law. The Act says it's collusion. It doesn't matter what SBD 4 says. It doesn't matter what anything else says. If there's anything at a lower level in the hierarchy of law that contradicts the primary law will prevail.
So multiple bids are not allowed. That's what you're saying with the primary law. It says that multiple bids are not allowed.
Yeah.
If declared or not declared, they're not allowed.
Yeah. I mean,
Is it possible if you can share that with me, Sean?
Sure, absolutely. I'll place that in the chat shortly.
Unless the Competition Act changes their wording.
Let's go back to who was it, Jacqueline, that asked the other question, Henry?
It was Komotso. Yeah.
So Komotso's talking about her experiences where organs of state are automatically disqualifying somebody if they're finding that that particular director is also directing other entities. And CSD flags up that they are directing other entities.
Yeah. So there are 2 aspects to that, right? There are 2 aspects to that. And Komotso did raise it. So firstly, and I want to come back here. So if it wasn't related enterprises, and I explain kind of what I interpret as related enterprises. If it wasn't related enterprises, then there was no onus. So if you were, for example, I don't know what other company, and you were also then involved in security services, and so there's no type of relation in terms of the services that the 2 enterprises deliver or give to clients, then you have no obligation here to say yes, because they're not related, the enterprises. However, if the enterprises are related, you're obliged as a bidder to answer yes to this question. Okay. Now, if it's found that through the CSD reporting that you are director of 2 companies, that they are not related, then you cannot disqualify. And so let's say that the bidder said no, okay, then you cannot disqualify that bidder, because then what they've reflected here was true. If they said no, it was true. If, however, you found in the SBDs that those companies that they were directors of are related enterprises, and they said no here, in that case, This SBD allows you then, in that case, not to consider that particular bidder. But it comes back to the related enterprise. So if you are a director of more than one company, and they are related enterprise. So let's say you're director of two companies that are related enterprises. You said no here, and it's then found out later through the CSD system. Then you can disqualify them. Okay, this SBD gives power to that. It's important though. If they're not related companies, and I think that's the trick sometimes, whether it's related or it's not related. But if they're not related companies, then you cannot disqualify them. That's absolutely clear from this SBD4. So I don't know if that answers Komotso's question. But that's my basically response.
Good one, Henry. I think it's the practice that she's seeing, and it'll be interesting to check if there are others that are also experiencing the same. Let's jump. I think Mike was next, and then we're going to jump then to Nazette and to Zakele. Hello, Mike. Welcome.
Hi. Thanks, Sean. Just a question, and I mean, I'm wearing my consulting engineering hat. Quite frequently, the state asks for a comprehensive joint venture to present offers or bids for the design and construction management of a project, which involves a number of different firms or skills required. In the field of consulting engineering, there are certain skills that are very, very scarce in the country. And quite frequently, we query with clients or prospective clients whether one firm can be part of more than one joint venture. And the answer we receive, yes. Otherwise, it's a case of first come, first serve. Instead of having 10 or 15 bids, you're going to end up with maybe 2 or 3 bids, because that's the available expertise in the whole country.
Correct, Mike. Yeah.
So according to what's been said, all those bids should actually be referred to the Competition Commission for collusive behavior, which is
there is a question on that, but just repeat again what the circumstance is.
There is a bid.
There's one bid.
Well, say the design and construction of a power station.
Correct, yeah.
Hypothetically.
And there's a very scarce skill, and that
for example, in the design of certain electrical switchgear,
correct,
or the selection of certain electrical switchgear, maybe there may be 2, maybe 3 firms in the whole country that can offer that service.
Got you.
Now, if you are part of more than one joint venture, that, according to what's been said, is deemed to be collusive behavior, which is quite baffling. Because all that means is you're actually reducing the number of potential bids.
But they're not directors.
They are. It's a joint venture. It's an unincorporated joint venture.
Okay. So,
and even if it was an incorporated joint venture, they'd still be directors because they have to be shareholders.
So they are part of multiple joint ventures.
Yeah.
As a joint venture shareholding company.
Yeah. Well, no, not necessarily. If it's unincorporated joint ventures.
Because very often, if it's unincorporated, they're there just as subcontractors. They're not shareholders.
Well, they're partners.
Yeah, the partners are shown because regardless if it's incorporated, sorry to jump in, regardless if it's incorporated or corporated, they are partners. There's risk that is shared. So
sure. Let me quickly, Henry, any thoughts on this? I'm just quickly going to the Competition Act.
Yeah, I'm just going to ask you to maybe pop that up, that thing. Because I think that's the thing, as the definition is I think what is problematic at this stage, but that's what's there.
I mean, I just provide a service and I give a price, and that's it. I don't know what the joint venture decides to do with my price or with the price of the services that they provide.
which is slightly different to being a director.
Well, no, you are an unincorporated joint venture. You're a partner in the unincorporated joint venture. It's considered a partnership in legal terms, if I'm not mistaken.
Yes, and just to add, Sean, what happens with the joint venture also, there's an agreement between the partners, and within that agreement, there's the shareholding that happens, corporated or incorporated, 30%, 70%, 50%. Hence, each and every joint venture or consortium usually will have a lead partner. So I think what Michelle comes in about it is that you will have a lead partner, and I'm coming maybe as a 30%, and I'm submitting, this is scope that I'm going to do. This is the pricing of the scope that I'm going to do. I don't know if Michelle, if I'm correct.
Yeah,
I hear you.
Let's just say, for example, if you are a specialist in high voltage relay design and how the high voltage side of the power station is going to be designed.
Got you.
There are, you can count them on one hand.
We understand. We understand the circumstance. Thanks, Mike. I'm going to find that slide and just share that with you. Let's jump to Nazette quickly.
Hi, morning, everyone.
Morning, Nazette.
So my question is just around process. So if you suspect collusion, do you automatically disqualify and then report to the Competition Commission? Or do you report it to the Competition Commission, wait for them to respond, and then disqualify?
Yeah. Any thoughts, Henry?
Yeah. So there would be two kind of scenarios there. So the first scenario is you could have suspicion where, for example, they not necessarily, so for example, around what I mentioned earlier, where they might have used the same contact details. They might have used the same contact details, something like that. In that case, I would most probably just report them. I would then just report them to the Competition Commission, and obviously not necessarily, because it doesn't necessarily mean there is collusion yet. Okay, but the example that we cited earlier in terms of where it was a shared director, in that case, given there would then be a stronger case. I still report them, but in that particular case, I most probably would have more right to kind of not consider them.
I mean, my suggestion would be that you don't disqualify, irrespective. What you do is you report them. And then if it is the one that is in contention, you then look at the risk and decide. But I wouldn't, and Henry, where I'm coming from is the competence to make a collusive finding rests with the Competition Commission. So I hear you. This thing that I'm sharing now is showing that this definitely is collusion.
Maybe not disqualify. If you, Sean, the issue just is then sometimes when you have to, and the issue that I've seen, for example, previously, is so maybe disqualify is not the right word here, but where you now have to make a decision. The practicality is that the decision, the Competition Commission, not going to come back to you in time.
Correct.
And you need to go ahead.
So at that point,
then to use objective criteria.
Exactly.
As maybe a better way to use objective criteria than to consider an alternate.
Exactly. Okay. So you then look at the risk, and then you say, based on what we see in front of us, the risk is fairly high, and therefore we use objective criteria to give it to someone else. Yeah. Interesting question, Nazette. Tabello, now you're in local government. You guys still use SBD 8 and 9, eh? MBD 8 and 9. Yeah.
MBD 8 and MBD 9.
Yeah.
Yeah. Sure. I'm just interested in this discussion to know how many people have actually gone through this process of reporting a scenario or a case to the Competition Act. And I'll be interested in that feedback because I've got my own experience with the Competition Act as well. The Competition Bureau. Yeah.
I'd love to hear other points. I've had good experience where they were fairly quick to come back to me in the process. It wasn't in time to make an award decision, but it was fairly quick. So there's a number of different loops that they go through. There's an initial, okay, we've got it, we acknowledge it. They call you up. They then refer that then to their legal team, and the legal team then could take a little bit of time to get back to you. But they do say, look, you've got a, seems like you got something here. We're going to refer it to the legal team. The legal team will come back to you. And that didn't take, it probably took about 3 weeks in total. What was your experience, Tabella?
Yeah, it's interesting. It's remarkable that yours was such a quick turnaround.
It was quick.
We have a case that's been sitting there for more than 3 years. You know, they kept on asking for an extension on that. Then it's being elevated to another investigative team and so forth. It's a never-ending story. By the time that tender is long forgotten. You know, we've moved on from there, and there was never any conclusion. They just kept on coming back and asking for an extension, supplying them with the documents, and you know. And the funny part is that before we even went on that, you know, our own accounting officer went out to source a professional legal opinion, and the legal entities up there said there was no collusion, and for the elements of collusion must be A, B, C, D, E, and there was no collusion. However, you had the same entity, same directors bidding for the same tender under, you know, one is a subsidiary and so forth, and one pitching at a very high price, one pitching at a very low price, and we see it all the time. I mean, we had one scenario where the same company had its own employee benefit scheme of some sort, where they empowered them. The empowerment scheme was for them to set up an entity in their own name, and they source quotations from the same company that they came from, and still not. Thank you.
Thanks. Good one. Thanks, Tabello. Let's go to Ilsa, and then we go to Zakele. Hello, Ilsa.
Morning, Sean. Thank you for taking my question. It's also regarding question 2.3, this related enterprise, other related enterprise. Is there actually a definition for it anywhere? Because in my case, majority of bidders, they will respond with a yes, and then they will list all the companies or the MAAA numbers of all the companies that the directors have interest in. And is it up to us to then investigate each entity and determine which one is actually a related enterprise, whether or not they're bidding for the contract or not?
That's a great question. Henry, your thoughts? So my thought is the SBD4 is a declaration. It's not a declaration of a conflict of interest. They're just declaring. Now, the key test, though, is this one that we were sharing a short while ago on the directors. And you want to then have a look. I think that's all you have to do, sincerely. If you just need to look to see, are there other bidders amongst those that they've listed that have submitted a bid? You don't have to go into each of them and ask the question as to whether they're related or not. If you conclude they are related, but they haven't submitted a bid, you don't disqualify them. It just means that one director is in multiple companies. It only becomes an issue if they have submitted multiple bids, if they have submitted a bid for that same tender. Ilsa?
All right. Okay. Thank you.
Right. Does that make sense? I mean, so it's if they declare that they have other related companies, so what? If they haven't submitted a bid, it's not an issue.
Yeah, it's just interesting that Treasury would ask a question like that if it doesn't really make a difference.
Yeah.
Because then they should rather say that they know of will be submitting a bid to be more conclusive.
Agreed. Remember in the old SBD4, Ilse? Go ahead, Henry.
It could also just be to protect you as an institution, Ilse, because I think, let's say, for example, the way they ask the question, because let's say, because somebody can always come back and say, they are director, but I didn't know if they were going to submit the bid. And so that's why they kind of cover themselves with that particular clause.
That's right.
The one bidder said that I didn't know the other bidder was
that's
going
right.
to submit.
That's right.
Yeah,
I think that was to cover that clause.
Okay. All right. Thank you.
Good one. Good one. Zakele, good morning. Morning, Zakele.
Good morning, Sean. Thank you.
We can hear you. Go ahead.
Yes. For me, I think Rafik has partially actually responded on text with the question I have. I've already made a decision in this regard, but I'm just trying to get your thoughts on it. A situation where you have two directors, they've tendered, and they did not declare that they are employees of the state. But then when we run the CSD, they appear as employees of the state. Correct. And then when you inform them that actually we have to disqualify you, then that's when they actually send letters from the other state-owned institution where they are listed as employees to say they were actually consultants that were actually paid or on rate related basis, but they are not permanent employees. They just consult from time to time. Yeah. So then what will be your thought in that regard? I've already made a decision, but I'm just testing the waters.
Henry? Do you want to share that slide again, Henry, what it says?
I'm just pulling up the slide.
So what happens is that there are people who are employed by the state and they have been given permission to work outside of the state and earn business outside of the state. So there are those that have been granted permission to do that. There are also employees, so-called directors of institutions, who would be flagged up on CSD as being an employee of the state, but they don't follow the normal employee definition. They're a director of another institution. And so what it says there, Henry, is you've got a right to that entity. You don't make a decision yourself. You write to that entity to request their advice on 1 and 2. Is that right, Henry?
Yeah, it says that a person with a bidding entity, if the evaluation establishes that the person with a bidding entity is an employee of the state, they must request the relevant. I don't know. Can you see the slide?
Yes, we can, Henry. Yes, okay. We can.
You must request the relevant accounting authority advice whether the person, firstly, could be either prohibited or then have permission to perform other remunerative work. And so based on that reply that you get back,
you take action.
Then, take action.
Good one. Good one. Sanele, I know you've had your hand up. Sanele, welcome.
Morning, guys. How are you?
Good and you. It looks like we're going to have a follow-up session on this one day.
Sorry?
It looks like we're going to have a follow-up session one day. There's lots of interest and lots of questions. Eh?
No, definitely. Look, the reason for lots of interest is because this is a section which, becomes a stumbling block between rendering services as an organ of state and, delaying yourself with the procurement processes. The procurement processes are a delay themselves. But there are parts where you definitely would have to play a deciding factor, or you use discretion as the organ of state in order for you to deliver services. For example, I think one of the colleagues was checking if you disqualify and send the the question or the names of the bidder to Competitions Commission for them to investigate or send that to them for them to diagnose it before they proceed. You know, I hold a different view on that because I believe that we are obligated to deliver services at the end of the day. We need to proceed. And firstly, you do your preliminary assessment of that problem. If you see that there might be some conflicting interest in this case, you can do your preliminary research. And if you find that maybe there might be prima facie evidence that leads to some conflicting interest, then you can take determination and the bidder's disclosure that was this declared. If it was declared, then you can then treat it as, okay, there was no hidden agenda around it. So you can look at the second question I was saying, were there a second bid submitted by the same person or same directors of these companies? Then you treat it in that sense of collusive bidding and work against or work towards solving the problem in line with the Competitions Commission Act provision.
Right.
And there were no disclosure, but you then find it in yourself, or you find it during the evaluation that there is an evidence that these are related companies. I can disqualify them. I mean, if you look at paragraph 3, paragraph, just 1 second.
Go ahead.
Paragraph 3.2.
Yes.
It says you understand that a company will be disqualified. It doesn't say even may. Will be disqualified if the disclosure is found to be untrue. So that's the ground which I believe you can disqualify a bidder if you believe that the information supplied to you is incorrect. Then you can then advertise the bid and allow for that cooling off period where everyone can ventilate their appeal, and you can that would be now. It can be argued that this is the reason why dispute in that sense.
Henry, do you want to go to that 3.2?
I'm trying to. I was gonna. Yeah, I've got it on the slide.
Just click on this. Click on the slide on the screen, and yeah.
Sorry, I'm just jumping down. I should have had 2 screens looking at the chats. Okay.
So that's what you're saying there, Sanele?
Sorry.
Yes.
3.2.
And that's the declaration part where you sign as a bidder. And there's another provision at the end which also emphasizes on this point.
Go down to the next slide, Henry.
That's the talking about 3.4.
You had it there. There's are suspicious will be reported to Competition Commission.
No, not the one. Let me just quickly show you if you allow me.
Give me a sec. Okay, you can share. Whilst you're doing that, let's jump to Razan.
This provision.
Henry, won't you stop sharing and
Okay, you see?
I certify that the information furnished in paragraph 1, 2, and
this, okay, yes, got you. That's the declaration, hey?
Yes.
Yeah.
So this gives you enough ammunition to disqualify if you are unhappy with. Because remember, we are evaluating, and I strongly, don't support the move to allow Competitions Commission to be in between evaluation process simply because of the efficiency of them. We struggle to get responses there, and I've tried to get some
absolutely
relationship when I was still at my previous employment. It's very difficult. So if you involve them in between evaluation, you're not gonna win.
Yeah. So let's just understand then, what you're saying is, if there's something that they did not declare on, and you find that they should have declared that, you have a basis then to disqualify them.
That's what I say, because look,
and if they did declare,
and if they did declare, that's what I'm saying now, you then check if there would be some conflicting interest in a sort of one bid submitting two bids.
Correct. Yeah.
In relation to these companies that you are picking them up from the evaluation.
Yeah. Then you would disqualify as well. That's what you're saying.
Personally, yes.
You would disqualify as well. Now, do we agree that in the latter case, you also have to report them to the Competition Commission?
Yes, that now would be a ex post facto
irrespective of whether they were the contending bidder, you have to report them to the Competition Commission.
Yeah, I think that's why it would be to satisfy your whatever processes that you probably want. But maybe they will come and appeal. So in that respect, you can get that as part of the assistance. Yes.
Yeah. All I would say is just think about the possibility of the Competition Commission coming back to you and saying there was no collusion. Just be sure that whatever you do in your decision on that bidder, that you are covered should the Competition Commission come back and say no collusion.
But sorry, Sean, maybe before I close, but mostly, the questions in these SBD forms and SBD forms, they would be saying, they would be asking you do you have any relationship with any other companies, either they're submitting a bid or not?
That's right. The first question, yes.
Yeah. And if you're saying no, and we're picking you up that you are appearing in other companies, that's obviously is...
That's clear.
Yes, it translates to false declaration.
That's clear. That's misrepresentation. Correct. And that's where 3.1 comes in. You have a basis then to do that. You've picked
Definitely,
it up. Yeah. Good one. Let's jump to Razan. Thanks. Nice to have you join us today, Sanela. Hello, Razan, all the way from City of Cape Town. Razan. I can see you've unmuted, but we can't hear you, Razan. Let's jump to Fabian and we'll come back to Razan if he gets his mic going. Hi, Fabian.
Hi, can you hear me?
Yes, we can. Hello, Fabian. Go ahead.
Perfect. Hi. I just wanted to clarify on the issue. So if you have a scenario where you have two bidders, they declare each other on the SBD4, but they also complete the SBD9. Would that not mitigate that risk? Because if you look at
you're asking now from a local government perspective?
Local government perspective.
Okay, so local government still has the old SBD4 and SBD8 and SBD9. Sorry, let me just say it again. The MBD8 and MBD9 and MBD4. Yeah. So what Henry was going through is the PFMA where they've dropped the SBD9, Fabian, which is an interesting one.
No, I get you completely.
So, but the same logic that you're saying applies. You're right. The SBD9 then would cover, and a lot of the stuff that Henry was going through at the back end of the SBD4, the PFMA SBD4 are the same questions that you've got, similar questions to what you've got in the MBD9. Good one.
I'm clear on that one.
Good one. Let's jump back to Razan and see if he's fixed his mic.
Morning, everyone.
Hello, Razan. We can hear you. Yes, welcome.
Thank you. I thought perhaps it would be a great opportunity to just share some of the practices that we do have at the city. I know we are in the local government space.
Correct. Go for it.
Some of the method in which Sanele indicated he would undertake the declarations or how he would continue with the process. I want to agree with it, yes. But I do agree with yourself as well that we do need prima facie evidence in relation to should the Competition Commission come back and say that there is no interest or collusion.
Yeah.
And then with our internal process, what we would do is obviously we would identify this in the evaluation process. It's the committee's responsibility to do a preliminary review of what the associated risks are.
Right.
And if they think there is any collusion, like you indicated, identifying similar information, doing background checks and so forth. From there, they would make a recommendation to the Office of the Director, SEM, whether or not we should do further investigation from a forensic perspective.
Right.
Which we would do. And we would also write to the bidders to provide them with an opportunity to clarify what we have identified.
Interesting.
This also allows us to use that information, should it be accurate or inaccurate, in any legal proceedings, any further Competition Commission investigations that's going to be undertaken going forward. And then whatever the outcome of our FSD recommends, we would usually notify the Commission if we have identified collusion. And in some instances, it's quite inconsistent. Sometimes they're very fast to respond, sometimes they aren't. But our declaration documents, our policies, the manner in which we communicate with our bidders allows us to use all of the relevant references, legislation, to support us with whether or not we consider them to be non-responsive based on the identified information. So we would cite the associated risks as well. What we also have as part of our process is due diligence, and they would also conduct a review in relation to the risks that we've identified to see what any mitigating factors they find based on the engagement with the bidders should they require additional information. But ultimately, it comes down to the BEC's decision again, whether or not they think that the bidders should be made non-responsive, taking into consideration all relevant information received and legislation and so forth. We aren't afraid to make people non-responsive. We know the associated risks of collusion and so forth.
Right.
So we're quite strict in our space. We're not saying that we haven't received appeals, interdicts, and all of those kind of things. It comes with the environment that we work in, but we're comfortable that we have the documentation and, like I said, our processes support everything that we want to implement.
So thank you, Razan. So if you conclude that this looks risky and that the risk is unacceptably high, do you then disqualify, or do you then use that in your consideration of 21F of the PFMA, triple PFA as an objective criteria?
Yeah, it's very tricky, and it comes down to the matter that's in front of us.
Yeah.
We also don't want to have the risk of an appeal coming forward.
Yeah.
So we see how we can make legal as close to the process as possible, so that we can continue and not keep the bid process still and from not continuing. But we have before disqualified people where we had factual or, like I said, concrete evidence.
Right.
And in other instances, we would just wait for the outcome of our investigation. Right. Sorry, guys, I'm recovering from the flu.
No. Thank you very much. We appreciate that. I was interested to hear whether you actually postpone that decision towards the end, and that if you feel that it is risky, that you use objective criteria to go to number 2 as opposed to number 1, and avoid this issue of disqualification. Do you use objective criteria 21F?
We do. I'm saying this very
Carefully.
Likely we do. However, again, our delegated authority is our city manager. So ultimately, he's the one that needs to give us the go-ahead.
Got you.
Okay. Thank
to
you.
to use yes,
Whether or
yes,
not we can.
to apply objective criteria or
yes.
Yeah, got you.
Okay.
Thanks, Razan. Thanks for
Sure.
joining us. Good. Sakele, you've raised your hand again.
Yes, Sean, I'm a bit concerned. Remember the discussion that we've just had with Sanele, where you can just disqualify. I tend to say you also need to check first. Don't just straightforward disqualify, because I've had a situation where during the tender submission, the tenderer made a declaration and that declaration was correct at the time. But circumstances change. When we're assessing, checking, and we found that this director is actually with another company, but that happened after they submitted. So meaning that now their SBD4 form, there was no misrepresentation, as per the procurement practitioner assumed that there was a misrepresentation. But when we dig deeper, and because we've afforded them an opportunity to respond to our position to say we intend to disqualify you, then that's when they indicated to say actually these changes that you found when you were running CSD happened after we submitted our tender. So it could not be that we misrepresented ourselves. So I'm just mentioning it so that the colleagues, it's not just a straightforward disqualification.
Very good.
All of the way, you need to do your own due diligence to ensure you avoid litigation at all costs.
Well done, Zakele. Good point, agreed. And I think Sanele would also agree with you on that one as well. Affording the bidder an opportunity to clarify is important, Razan says. Let's just quickly run through some of the questions then. Tokozile, the recent incident experience RFQ response SBD4 were completed by two different entity directors. However, the CSD report submitted physical address was the same. Is it sufficient ground or any ground of collusion for disqualification? Any thoughts on that one, Henry? Khomotso then saying, remember, it is a thing now that people do share offices, so it's not necessarily that there was collusion. It comes down to my kind of starting point is that the competence to conclude collusion rests with the Competition Commission, not you. Now, it sounds like at City of Cape Town, they're doing a lot of forensic work as well, and they're trying to look into it. Not everybody has got the same resources that the City of Cape Town might have. And so I would rather let the Competition Commission conclude the collusion aspect, and you conclude risk. So you look at this thing and you say, now, it could be, it could not be. It could be that there is risk. It could be that there isn't risk. Let's not disqualify them at this point, because if the Competition Commission comes back and says there was no collusion, then you're the one in trouble. Rather continue the process, and when you get to the end, and if that is the one that is in contention, you take a risk decision. Not suggesting, as Sanele might have been thinking, that we sit and wait now for the Competition Commission. You don't wait for the competition. If you've got to continue and deliver services, you say now, what is the level of risk? And if that level of risk is unacceptably high, you use objective criteria to come in and help you on that one. So be very careful about making these decisions on these aspects. It's got to be very clear and prima facie evidence, as Razan said, for you to do that. Don't just be suspicious. If it's suspicious, you still got to report them, as the SBD4 says. Thanks, Martin, for your comments. Any other questions, everybody? Gee whiz, Razan, did you want to come in again?
Apologies, I didn't lower my hand.
No problem. Let's go to Mike. Hello, Mike.
Sean, just a question. How confident are you of the Competition Commission? Because when they end up in on anything, because whenever they end up being challenged, they normally come back with a tail between their legs. You know, relying on a third party to make a decision like that, and they make the wrong decision, it could actually have substantial financial implications. I mean, you know, if you look at the aspect of tariffs, the Competition Commission has ruled that tariffs are horizontal collusion, yet every medical aid works on tariffs. So, yeah, I have my reservations about.
I mean, I hear you, but you and I can't put ourselves above the Competition Commission in terms of the rule of law. Right? We can't say, well, we're going to ignore them because they've made poor decisions on a range of things. That's not for us to do.
But if you abide by their decision and their decision is wrong, you're the one who carries the can off.
Okay. No.
Yeah.
So
you disqualify a bidder
because the Competition Commission has come back and said there is collusion.
You're going to be one of the respondents.
You will be a respondent, but the Competition Commission has concluded that.
Yeah, I don't know. I'll be very wary because, you know, you could be saddled with substantial costs.
Here's the issue. If you ignore that decision and you're challenged because you've ignored that decision, it may be even more difficult for you at that point.
Yeah.
Right? I mean, you can't ignore the decisions because of a track record.
Yeah, I hear what you say, but maybe these decisions shouldn't go to the Competition Commission. They should be confined to the office of the Chief Procurement Officer. It's some sort of a tribunal.
It will certainly change. It will certainly change under the Public Procurement Act.
And once again, make the OCPO Chapter 9. Then you free of everything.
We wish.
Anyway.
Good one. Let's jump to Jacques. Jacques asked a question. What if same directors in the case of a niche market, health, or for example, participating in the same tender, but on different items? Yeah, Jacques, you've raised that question, right? So you're saying there's a bill of materials, for example, or in the pharmaceutical industry, there's a whole range of different pharmaceuticals, and one bid submits for this range of pharmaceuticals, and another bidder submits for a different set of pharmaceuticals. They're not submitting for the same pharmaceuticals, and therefore it's not necessarily the same bid is what, Jacques, your question might be. But I'm just going to ask Henry to just flash up the second last slide that he had there, 3.2, 3.3. Jacques, the issue is that they have colluded. Like they have decided who's going to respond to it. And that is by definition collusion. And I think it would be a tough one for them to argue against. I think the process of getting to that point. The bidder has arrived at the accompanying bid independently from and without consultation, communication, agreement, or arrangement with any other competitor. However, the communication between partners in a joint venture will not be construed as collusive bidding. Jacqueline, go ahead. You might have a different view on that.
So usually what happens is that I'm just now basing it also on the past experiences.
Yeah.
If it's different items and they're not same tender, but they're not tendering for the same items,
right,
that is not deemed as being a collusion because they're not competing for the same item. Make an example.
So how do you explain that against 3.3?
remember, the way I understand 3.3 is speak if we are now tendering for the same items. Now we're competing.
No, it doesn't say that. It doesn't say that. I mean, how do these two entities decide what one is going to go for and what the other one's going to go for?
Okay, let's go to the key important word solution, competitor. That is the key word there. Any competitor. We are in the same tender. We're not competing on the same items. I'm tendering for a different item, which is item 1, 2, 3. And the other one is tendering on item 2021-23. So we're not competitors there.
But they're related, aren't they?
They're not related. Even when we go to ranking, we won't be ranked in the same basket.
They won't. I agree. We won't be ranked. I agree. So you're using the competitor as the basis to say they're not competing and therefore it's not collusion.
Yes, that is the key
word in that paragraph. Yeah. I mean, I hear you, Jacqueline. If we've got, come on, Jacqueline, we've got the construction industry gets together and they decide that you're going to go for this stadium and we're not going to go for it, and you're going to go for this stadium and we're not going to go for it. They're not competing, and therefore there's no collusion. Isn't that the essence of collusion?
Remember now it's different different stadiums, different specifications, different requirements, which
it's just the act of getting together and deciding who goes for what is the essence of collusion.
But we're not bidding for the same stadiums.
No, exactly. That's the point.
But how are we competitors then?
No, well, we're not competing because we're not going to go for the same stadium.
Yes, we're not competing completely.
But that's the essence of collusion.
Collusion is when we're competing for the same bid, and I say that I'll go high.
It's not. If you've decided as construction engineering companies not to compete for this stadium, and we'll just let Group 5 go for this stadium, and no one else submits, and then somebody else goes for another stadium and nobody else submits. They've all sat down in a room and decided that. You're saying that's not collusion?
That I understand when you're explaining like that. But in situations where, I'm just speaking now on practice now, where there's different items and you find that there's let me take it back to the situation at JV. I have a JV with you. It's a big tender. It's got different phases on it. There's a JV that I have a JV with you in a certain scope, and then I have a JV with Henry on a different scope. That usually is not deemed as being a collusion. It's different scopes.
Yeah, I'd love to get the Competition Commission's take on that. So, Chris, you've got a different view there, I think. I don't know if you want to come in, Chris. Chris has got a legal background as well. And I think, Jacqueline, you also have a legal background.
Yeah, Sean, I was just actually agreeing with you. You know, the very fact that you're sitting down and deciding, well, we're going to go for these items and you go for those items, that is definitely collusion. And you're going to be for the high jump. Yeah.
I think, Jacqueline, I think it's a very tight line. Jacques, interesting one.
Again, I think it's sorry, Sean, to come in. Again, it depends. If I'm specializing on a special field and I can only tender for this, I'll go for that. Remember, you have companies that have different departments and they specialize on different items. Would that you call it a collusion if you say that we're tendering for that as a company because we specialize on wires, and then as another facet, we're specializing on windows? Are we now in collusion and we're tendering for the same tender but on different scopes?
You won't be in collusion if you just decide independently which items you want to go for. But the minute that you have any communication with the other party and say, all right, we're going for these, you're going for those because we have different, there shouldn't be any need for communication anyway. You should rather just keep your distance and bid for the items that you want to bid for, and let them bid for the items that they want to bid for. There might even be overlap, which would then really show that there's no collusion. But the minute you have some communication or agreement or arrangement, then that's collusion.
Okay.
I think the Competition Act as well says substantial shareholding and or director, common director. I think that would be the first thing to look for. So if if they do arrive at that independently, that decision independently, but there is a common director, it would still be looked into.
That would sniff of collusion.
Yeah. And I think that's why the Competition Commission would be brought in then, Jacqueline, is to look into that kind of thing.
Correct.
And I think it's I mean, Jacqueline, I think your point is still right, though. These are difficult decisions for very often procurement practitioners to make. And so yeah, I would just caution on disqualifying based on these kinds of things. I think you've got to develop a much stronger case than these kinds of things. Jacques, go ahead, Jacqueline.
Yeah, I think what helps the most, it's if your SAM policies and procedures, they protect you when it comes to this situation. There's a guidance on how to mitigate the risk when that situation comes to play. With the City of Cape Town, it's most of the things are embedded in their SAM policies, and also it get transferred to their tender documents. So they are covered in that manner. As in with the PFMA, that is not necessarily is the case. I think that's where the challenge comes in.
Yeah.
Is that when you come to those situations, how do you manage them and navigate yourself out of them? Whatever decisions that you make at the end of the day.
Jacques is just raising that if you've got sister companies and different companies have got different licenses for different pharmaceutical items, you know, so you've got a big pharmaceutical group with subsidiaries, and this subsidiary has a license for these items, and this subsidiary has a license for these items, but there's a common shareholder. That it may not be collusion, I think is what Jacques is saying, because the license is specific to those different entities.
Yeah, Jacques, it goes back to what I've touched on that specialize. You specialize on a certain field. Yes.
Yeah, that point on Henry's 3.3, the slide that he's showing now. And I think it's Chris's suggestion is rather than just submit as a joint venture, because it will not be construed as collusion. But yeah, interesting one. And just
oh, sorry, I was just going to say there was also a point earlier I saw in the chat from Marjorie. We addressed the question, but it was a slightly, we addressed the question, but it was a slightly different questions. There were cases where CSD shows the government employees, but when we look at the DPSA verification, then there's no proof that it is a government employee. So as I said, we did address the question, but it was as part of another question. I think that the bottom line just is that If you see it on the CSD, you still want to go back to the organ of state, to the other way, you know, and ask that company, where's the point? You want to ask that company this particular questions. Where is it? Yeah, this particular thing. Whether they prohibit, whether that particular person or persons are prohibited from doing business with the state, or whether they got permission. So I think that's still that's the same answer basically we gave earlier. It's a different question.
Yeah, I think just thank you, Henry. Coming back to this multiple products thing, and Jacques' question around the licenses. Do you just want to mute again, please?
Sure.
I mean, my view on all of this is that as procurement practitioners do not conclude there's collusion, if it's not yeah. Okay, let me finish what I was going to say. Do not conclude it's collusion and disqualify immediately. Continue the process. If it is the one that is in contention, then look at that and take a risk decision. Be very careful about just automatically disqualifying. Now, that's slightly different to what Sanele was saying, where he's suggesting that if there is prima facie evidence, then you go ahead and you disqualify. Two points of view. Sanele, there we are. You've raised your hand.
Thanks, Sean.
Interesting one, hey?
Yes. You know, I wanted us to look into this matter, maybe not necessarily confining ourselves to collusive bidding.
Yes.
Only. Let's look at it in a sense of competition. Because that's why I think, you see, that's why it is referred to the Competitions Commission, because it touches on the competition.
Yeah.
So the issues of fragmenting competition, that's what actually the whole thing is trying to deal with.
That's right.
So there are a lot of other bad practices that may arise, which include the collusive bidding, but you will have, your bid rigging, which would occur, now and then when these service providers are agreeing to say, we here in KZN, you will be working in Cape Town and the others will be working in another province. So at the end of the day, we are partners, so you are not coming to work here, and the other ones are only, working in Cape Town. So then that's how they fragment the market. There's another one which will be cover quoting, the obvious one.
Sure.
Which now say you're gonna quote this organization higher than me because it's my turn. And there's a bid suppression, which is we agree that no, none of us are going to bid because we're allowing you, or we withdraw the bid to allow you to win. There's bid rotation, which will say this bid is mine, the next one is yours, the other one, that's another bad practice that fragments the competition. There's a loser's fee. There's a loser's fee, which would say, okay, I will lose, you will pay me this fee so that you can carry on with this bid. So there are a lot of these things, including collusive bidding. So when you deal with these things, we must deal with them in a sense that we look at it in a competitions issue, not necessarily on collusive bidding, because it's going to limit our assessment of it. So we had a session with Competitions Commission some years ago around this issue, and that's what we were dealing with on trying to make sure that how we save government from these things. But it's big. That's why in the end you'd have to refer the matter to them. for them to employ, the necessary resources to deal with these issues. But sorry, in the end, when you deal with it organizationally, you deal with it in the sense of what you've raised earlier, Sean, by assessing risks. What are the risks involved in continuing and accepting this bid?
Yeah.
Because that also is within your jurisdiction. Sure.
Very good, Sandile. Thank you for going through all those different collusion and corrupt practices that exist. Thank you, everybody. Henry, thank you very much. You want to put your camera on just so we can see you, we can thank you, and thank you for that. Very, very interesting session. Probably the highest attendance we've had ever. Pululeku, common collusions, bid rotate. Okay, there are bits of question there where you've got it. Good one. Thank you. And thanks everybody for your participation. This has really made me think about the topics that we should be focusing on. These topics that are very practical and touch issues such as SBDs and MBDs are very much issues that people are dealing with. So very interesting that we had such a great turnout, and thank you very much for your preparation, for your time, Henry.
Okay, sure.
Thank you everybody for participating. Great discussion. Thank you. Good points from everybody.
All right, thanks. Cheers, guys.